Yeah, what I would like us to do is to take questions, we discuss the questions, and then we keep coaching you on how you should prepare. So we're not going to do any specific topic, but you will rather take questions and issues from your end so that we discuss together. Since you are doing revision from your own different places and learning on your own, but it's still important that we keep coming back to the basics that we should guide us so that we are able to put our thoughts together and respond to questions. Because as I keep saying, a good number of you, the problem is not about the knowledge. In terms of you not knowing or understanding the topics under the 6 examinable subjects, but more importantly, how you are able to utilize the knowledge you have to organize a very coherent and logical response to questions which are going to be asked. And as you know, the questions we are going to expect this year going to be one of two permutations, either essay and problem or half all essay or half all problem. So that is what we are expecting, and we know that very well because the Independent Examination Committee have made that public. So therefore, I'm going to let you bring up specific questions. So maybe probably let me have a guided interaction. So maybe let's start from Ghana legal system. We're going to do that for a few minutes, then we take another subject area. So the questions that have and the issues that we have, then we trash that. So this will be the mode of engagement. If you like to ask a question, you raise up your hand, and then I will unmute you so that we can take what you want to say. Or you probably use the chat, and then we take it from there. So the first set of interactions, all questions which are bothering you as far as Ghana legal system and legal method is concerned. So I'm going to do that for the next 15 minutes. Then when you are done, we take another subject, constitutional law, land law, in that order. Okay, so feel free to put up your hand. You don't need to mention your name if you don't want to. Just you can just speak. Yes. Who is taking the first shot? Any hand up? Yes, any hand up? If you are shy, you don't have to mention your name. Just raise up your hand and then just speak. That is fine. Wow. Nobody wants to ask anything. No questions? We should bring the exams forward so that you can write it earlier, since you seem to be 100% prepared. Okay, I think I've seen one person hands up. Let me unmute the person. Oh, you put your hands down. Okay. Unless you raise your hand, otherwise I can't see. You put your hand back. You put your hands down. Okay. The raise hand. Let me see. Okay. Yes, you can unmute. Yes, you can unmute. Yeah, Kojo, go ahead.
Thank you, Doc. Doc, thank you for the opportunity.
Good.
Doc, with the new act, the Land Act,
Yes.
and you know, the Borrowers and Lenders Act also has something to do with property.
Okay.
So I'm looking at the impact because there's a recovery when it comes to land matters and then also the borrowers and lenders. So I'm looking at the impact of the Borrowers and Lenders Act and then that of the Mortgages Act, especially where the two conflict.
Hello.
Where there's a conflict between the two, which one precedes the other? Yes.
If I understood your question well, you would like to know the relationship between the Borrowers and Lenders Act 2020, Act 1052 on one hand, and then the Land Act 2020, Act 1036 on the other hand. And your question is in relation to
Yes.
recovery. Are you talking about debt recovery? Kojo, are you talking about debt recovery? Hello, Kojo. Oh, you've lost him. We've lost Kojo. But I think that if Kojo is talking about, let's say, mortgage, probably his. Yes, Kojo, let me bring you back. Yeah, okay. So if you look at the Borrowers and the Lenders Act of 2020, okay, just in case you've joined us, what we are doing is that we are doing questions and answers tonight. And I said that people can ask questions. Initially, I wanted to do a structured discussion. Yeah, sorry for the network break. I am back. Yeah, so a question has been asked regarding the relationship between the Land Act 1036 and then the Borrowers and Lenders Act 1052. Both legislation were all passed in 2020. So first and foremost, we need to understand that the main focus of the Borrowers and Lenders Act is to structure the lending agreement and, more importantly, to provide a framework of registration of security interest in collateral. You know, when you take a loan, collateral is demanded by the lender, and the collateral is supposed to ensure that should there be a default, you will be able to actually get something to hang on to so that your money does not become a complete loss, as it were. So that is what requirement of a collateral is supposed to do. But then there may also be a challenge in terms of the same debtor having used the same property, for example, to raise various loans. So let's suppose that it is a land, right? He decided to use a land to as a collateral to raise a loan. We have to remember that the Mortgages Act, which is called like the Mortgages Decree, it has not been repealed. It's still very much part of the laws of Ghana. Because if you look at section 88 of the Borrowers and Lenders Act of 2020, if you look at the which governs repeal and savings, it says that the previous act on borrowers and lenders, which used to be called the Borrowers and Lenders Act 2008, at 773 has been repealed. But it did not say that it was repealing the Mortgages Decree or the Mortgages Act. In the same vein, if you go to the Land Act itself, Act 1036, if you look at section 282, section 282 of Act 1036 contains lists of legislation which have suffered what we call the consequential repeal and savings and amendment. Now, if you look at the list of the repealed legislation by the Land Act, Act 1036, you notice that the Mortgages Decree or the Mortgages Act have not been repealed. Now, what that means is that the Mortgages Decree or the Mortgages Act is still very much part of the laws in Ghana. And as you remember, if you are talking about using a land as a collateral, right? So that one, you have a mortgage, you have a mortgage in respect of that. And as you know that mortgage is an encumbrance. It's an encumbrance or it's a charge. And the charge, of course, is defined as like an encumbrance. And you have to have it registered within the scheme under the Mortgages Decree. So the person who asked the question, unless you have some specificity, otherwise, if you are just speaking in general terms, then we say that the two sets of legislation that you raise, that is the Borrowers and Lenders Act 2020 and then the Land Act 2020, they are doing different things. And as I indicated, the main purpose or the main focus of lenders and then the Borrowers and the Lenders Act is to provide framework for registration of security interest in collateral and so on. And again, if you look at section 45, for example, section 45 of the Lenders and Borrowers Act, and I quote, if you look at that, we are told that a security interest in an immovable property in the form of a mortgage that is made effective against a third party under this act has a priority over any other mortgage subsequently registered under this act, the Home Mortgage Finance Act or the Mortgages Act. Now, so what is happening is that you will need to appreciate that the Borrowers and Lenders Act, for example, does not repeal the law we know in relation to mortgage under the Mortgages Act. So anytime you want to look at security interests or collateral in relation to land, it's not only just the Borrowers and Lenders Act. Of course, an argument will even be made that the Borrowers and Lenders Act, as it were, have come to create a bit of like a complication, but the sponsor of that legislation is the Bank of Ghana. And the purpose is actually to help financial institutions so that they will be able to have a fairer and equitable system of borrowing and lending. And they don't cheat borrowers, and then borrowers also don't take advantage of lenders. And that is why that legislation is there. So Kojo, unless you have some specific any other question or contribution? Whose hand is up? Okay, so since you are not forthcoming with questions, let me also bring this question up, and then I will take your responses. The concept of ownerless land is no longer relevant under the Land Act 2020. Discuss. Any thoughts? The concept of no ownerless land is no longer relevant under the Land Act 2020 Act 1036. Discuss. Any thought on that? Or you can unmute yourself and make sure that when one person is unmuted at a time. It appears some of you don't know how to raise your hand. Yeah, you can unmute yourself, but make sure that only one person is speaking at a time. Yes, who will have a go at that question? What does it require of us? The concept of no ownerless land is no longer relevant under the Land Act 2020 Act 1036. Discuss. Are we together? If you are not interactive, I will end, because that's what I'm doing with you tonight.
Doc, we are.
Yes. If I'm just doing just a direct lecture with you, I'll not ask you a question. But if you're having questions and answer session, I want us to be interactive. Yes. Yes. So, Mr. Azun Tabak, can you have a go? The concept of no ownerless land, maybe let me put it in the chat. Let me see the whiteboard if it will work. Let me see the concept. The concept of no ownerless is no longer relevant under Land Act 1036. Please look at how I've written the Land Act. And some of you examiners complain that the way you write legislation is not good. That somebody will write, I've seen situations where somebody will write Land Act, right? Land Act, then you not even put the 2020, you do like this. You let the Act 1036 come and put the 2020 like this. That is not how it is done. My power is going off. Let me just put the power on. Yeah, so in the proper format is that you have like the short title of the legislation, followed by the particular year. And then in the parentheses or the brackets, you have the serial number of that legislation, which is Act 1036. Good. So the question is, and the concept of no ownerless land is no longer relevant. The Land Act 2020 Act 1036 discuss. Sorry, the internet connection is not very friendly tonight. Sorry. Okay, so this was the question we're looking at. Yeah, so if you have a question like this, what will be your attempted response? Anybody can just unmute yourself and then start talking.
Doc.
Yes.
Good evening.
Good evening, Joshua.
Thank you for the opportunity given. My opinion, I think we will look at this question from the right in or right over the land we have. So I will pick it from this session 2 coming, where the allodia, the issue factory, the common law freehold, and those kind of stuff, so that I will, after that, I'll come and interject that the quote which was made by Mensah Saba, with the effect that we don't have ownerless land in Ghana because it's either a family land or it's a stew. So there is nothing like ownerless land, but all the land we have owners to it, either being the family, the stew lands, and whatever. That is how I'll pick it from.
Okay. Okay. All right. Thank you, Joshua. Yeah, that is a good attempt. Except that it's not a complete response. Yeah, Azun Taba, you want to speak?
Yes, sir, Doc. Good evening.
Good evening.
Yes, sir. Good evening, Doc.
Good evening.
Yes, sir.
Azun Taba, yes.
Please. If I know that this, for me, I think the question is purely essay type. Okay. So what I will do is that I will first of all define land. And after defining land as my introduction, I will now look at it from how ownerless what ownerless land means to me. And from there, I will go to, the theory of unowned land, where in the case of Ababio and then Kanga, it was explained. Then from there, I will now go to Ohime and then Ajay, how it was also defined or how land was acquired as at that. Then from there, I will now come to how in the new act, how interest in land is acquired. And I will enumerate them and then intersect the two. That is how Ohime Ajay determine how land is acquired, and the current act, how it has given the interest or how land is, the interest in land is acquired. Now, when I do that, I will draw my conclusions from the interest in the new act.
So what will be your potential conclusion?
My conclusion will be that when you look at the current act, Act 1036, you notice that even individuals can now acquire even allodial title. And even the state is also now owners. So in that case, you will notice that anywhere that a land will be unowned.
Okay.
Yeah, that is my take.
Okay. All right. So we have two responses. Unless, yeah, somebody hand is up. You can mute yourself. The person who hand is up, you can mute yourself and then.
Yeah,
Kojo.
Doc.
Yes.
Speaker just said.
Okay.
The fact that now under the new act, the subject grantee and then also do I say or what is the term for the opposite?
Grantor.
Stranger.
Okay.
Grantee now recognizes that yes, there is no ownerless land. So the fact that you've been there 50 years above or several years doesn't mean that you will maybe engage in adverse possession. You recognize the allodia owner. And the act, I think specifically section 5(1)(b) says that yes, you have to, if there's an alienation to the stranger, the allodia owner must be, the permission must be sought through written permission or written consent. So I'm just adding this to the point made by the previous speakers.
Okay, all right. Okay, let me comment on your responses, then we take another question. Yeah, okay, I think the three contributors are not doing bad at all. The points that they have canvassed, I think they are all relevant in answering the question. Except that if you look at the question, it's talking about the concept of no ownerless land not being relevant under the current legislation. So a good response will, first of all, let us understand the context, or that is the background in which this so-called doctrine of no ownerless land was propounded. The historical context, right? The historical context, and of course, he made the effort and alluded to John Mensah Sember's writing, in which he also reported the cases, Kanga case and all that, as the court having actually recognized that we have no ownerless land, meaning that every parcel or every piece of land in Ghana is owned. Now there's another historical twist, which is the Aboriginal Rights Protection Society, right? If you go to the Aboriginal Rights Protection Society, I think around 1893 thereabout, when there was an effort by the colonial government to pass a legislation to vest all lands which were not being cultivated, not being occupied by the people of the then Gold Coast, to vest those lands in the crown, in the British crown, so that more or less they will be held by the Queen, who was the head of state at the time, on behalf of, if you like, the people of the Gold Coast. And then the intelligentsia or the Aborigines Rights Protection Society, as part of the argument they made, was also that there's nothing like an unowned land, so to speak. So they resisted it. And that thinking also made its way into being recognized in some of the cases which came before, like the colonial courts, as it were. So that is the background. But then we also have the other challenge to that concept. And your responses did not actually bring out the possible challenge to the doctrine of no ownerless land. I'm referring to Professor Kluje. When Professor Kluje wrote his work, Ewe as in Law of Property, and when he wrote his work, Ewe Law of Property, Professor Kluje actually disagreed with the proponents of the concept, the doctrine that we have no ownerless land, because in his view, that doctrine has no proper foundation, not grounded in serious empirical evidence. But according to him, it's not the case that they had done a serious survey, and then he have actually discovered that, okay, as at the time that the doctrine was being propounded, that if you look around the entire Gold Coast and all that, certain lands they were all occupied. And for that matter, we are convinced by saying that we have no ownerless land. But then Professor Kluje also argued further that even the court in the Kanga case, which made alluded to Mensah Saba's writings, and they made that recognition, was also not founded on any serious proper evidence. So in his view, that doctrine was not true, and nothing, if not for nothing at all, from his research, that is, Kluje claims in his Ewe Law of Property that in Volta region, he had come across parcels of land which were ownerless, meaning that they did not belong to anyone. I mean, that is just for the scholarly debate, aspect of the question. And I think that you need to also show awareness of some of these scholarly debates regarding the doctrine before you add the other thing that yes, those who actually support, I mean, Professor Kluje is just in the minority, or is in the isolated case, in the sense that apart from his dissent from the plausibility of such a doctrine, we don't have any other body supporting that. So let's come back to no ownerless land. And as they have rightly argued, if you look at the Ohimen and J, Ole no J, as he then was, and so on, give us a very good account of how land is actually acquired or owned in our system or in our society. And if you look at the Land Act, you notice that the Land Act has actually not done anything by saying that we have ownerless or you don't have ownerless land. So all that it has done is just to build upon the range of customary land law interests recognized in Ohimene Nejei, and also even to add others which evolve from the common law. For example, as you know, like the leasehold interests and so on. All these they are the common law dimension. But otherwise, if you look at the section 1 of 1036, all the things over there are known as customary law under Ohimene Nejei, allodial title, the customary law freehold, usufructuary interests, customary interest. So the other additions, which are also recognized as interest in land in Ghana, the common law dimension, the common law freehold, and then the leasehold interest. Yeah, so therefore, the concept remains really valid, and is even more relevant now. It's even more relevant now than when it was first propounded. And for that matter, if Professor Kludze were to write another edition of his Ewe Law of Property, I am quite positive that he will revise his opposition to the doctrine that there is no ownerless land in Ghana, because as we speak now, it is even more, it's convenient and very easy for you to agree that to the truth of such a proposition. Okay, so we leave that here. Let's take another question from you. Yes, let's leave this one and take another question. Yes, any issue? I said we are going to do team by team, but we couldn't stick to that. So people just brought questions from various directions. So that is still fun. So let's keep going. Yes.
Respectfully, I want to just ask that as it stands now, do we have judicial decisions on the fact that there are no lands that are owned?
The no ownerless land.
Yes.
Oh, I think there are some very old cases, reported in John Mensah Server's Frantic Customary Laws. They are not in any other report. I think, okay, I mean, RENA report, and then also in the John Mensah Server's Frantic Customary Law, like you mentioned the how do you call it, the Kanga case. I think there are four such cases there which you could actually cite. But as I said, those cases are very historical in the very early stage, the 19th century, okay, not the 20th century. But as I said, nobody will now even contest the claim that there are no ownerless land in Ghana. I mean, if you have to do even empirical research, I doubt whether you get evidence that we have a land which is just lying there, not belonging to anybody. I don't think so. Okay, what else? in case you've just joined, we are doing a Q&A. So we allow people to raise questions, bothering them, then we discuss them together. Okay, so somebody would like to find out with the given trends in corruption cases. Let me take the question and put it on the whiteboard. Yeah, so I'm copying the question. One of us push. Just 1 second, please. Let's see if it can come as a sticky. Don't think you can see it's so tiny. Okay, so this is somebody's question. With the given trends in corruption cases in the country, how do we approach this question from the legal point of view? So the person is interested in questions to do with corruption. Well, maybe I will recommend that Professor Justice Datiba has done, those of you who have come across his book, Selected Papers and Lectures on Ghanaian Law. I think it's a very good work. Now he has an article on the, integrity, right? He has an article on the integrity, and I think that it will not be a bad idea if you read it in order to build a general appreciation of the whole issue, especially so if the question is not posed as a criminal law question. Of course, in criminal law, we know no bribe, where somebody we charged with the offering bribe or accepting bribe, bribe, and so on. So the criminal law aspect is quite straightforward. But if it is not framed as a question emanating from criminal law, and it's a question which, for example, invite you. So let's take this one, for example. Just take a question like this. Let me put this one here. Test. So let's take this. Okay. Okay. So let's say that Ghanaians have expressed concerns about increasing allegations of corruption and abuse of office by public office holders. You have been invited to submit a memo to Council of State. Council of State on what can be done to address the problem. So still the same corruption matter. Ghanaians have expressed concerns about the increasing allegation of corruption and abuse of office by public office holders. So you have been invited to submit a memo to Council of State on what can be done to address the problem. So if you have a question like this, how will you go about it? Now I've told you that, okay, let me take some responses before I comment. Yes. Okay, somebody has brought a related question. So same idea. So let's take it so that we address them together. Somebody has brought a related question that, put it another sticky note. I think one of us have brought a question that despite the manifold laws and institutions, corruption remains endemic in Ghana. Discuss. Okay, so these questions are all related in one way or the other. It's just a question of the format in which the question is presented and in which it's supposed to be responded to. So if, as I've told you before, never be bothered as whether the question is asking you to do a memo or for you to do whatever. It's still the substance which really matters and not so much the form. You not writing memo at the top and so on and so forth is going to let you lose marks. No. I've told you that LLB, we don't do legal drafting. So that is not the focus of your examination. The focus is more on the substance of what is being asked. So let's come back to the question. If we have a question like this, as I said, all the time, essay questions, we need to be structured in our approach. Let's be organized. Don't let us write like non-law students or non-law persons, okay? Because this same question can be solved by people who are not law students, those who are just doing journalism, those doing political studies, or whatever, just name it. But this is a law paper. So let us be mindful of that. So so what are the points which we need to have in mind? What are some of the things which you think, which in your view should go into question like this? Points to consider. Yes. We can just get the point before we organize them into neat arrangements. Yes. What are some of the points?
Hello, Doc.
Yes.
Yeah, we need to mention the establishment of the Office of Auditor General.
Okay, so we are just listening. Okay, come and arrange them. Establishment of Office of what? Office of Auditor General.
Auditor General. So Article 187.
Article 187.
And also the Attorney General Office, that is 88.
Attorney General. Okay, that's great. 88. What else? Yes, what other points must go into such a question?
Yeah, so we can also talk about Shraj.
Talk about Shraj.
I think 1-2-1-6.
Shraj.
And
2-1-2-1-6.
6. And I think NCC can also play a role by educating creating awareness. So NCC, which is 231. That is all for my side.
231. Creating awareness. Okay. Any other? Yes, Amma. Can read yourself. Yes.
Yes, we can also, to add to what the earlier, my earlier colleague said, we can also add Article 35(8), what the state says.
Article 35.
8.
35.
8.
Okay. It says that
the state shall take steps to eradicate corrupt practices and abuse of power.
So that's the directive principle of state policy.
Yes, under chapter 6.
Okay. Okay. So obligation of state.
Doc.
Yes. Come in.
I think
a second. Obligation of state. Can you see the whiteboard, by the way? Can you see the board? What I'm writing on? If you cannot see,
no, Doc.
You cannot see.
I cannot see it on my device.
Oh, I'm using like a whiteboard, just like a blackboard. If you cannot see, then
it's blank.
Really? Can anybody confirm?
Yes, I can see. Yes, I can see. I can see the white. Yes, please.
Okay, all right.
It's blank, Doc.
Maybe from your settings. Obligation of state to deal with corruption, abuse of office. Okay. Okay, what else? Yes, somebody wanted to ask something.
Yeah, I had wanted to also avert our mind to Article 23.
23.
Yes, sir.
Okay, that's administrative
bodies and officials should work fairly and should comply with the laws that is imposed on them.
We have a point 1. Two. We come and arrange them and also add.
Doc, sorry, we can't see the whiteboard. So if you can,
really?
Maybe post it in the chat.
Oh, right.
Then some of us can benefit. It's not all of us that can see.
Oh, okay.
No, please, we can see. We are following.
Okay. All right. So all that you have said.
Please, we are following.
All right. So all that you have said is that somebody said the person interested in thinking about questions on corruption. And I said, okay, that is fine. Then let's imagine a question. So in attempt to imagine a question, I think another one came up. I said that you've been asked to do a memo to Council of States explaining what can be done to address increasing allegation of corruption and abuse of office by public office holders in Ghana. And then somebody brought a related question that, quote, despite the manifold laws and institutions, corruption remains endemic in Ghana. Discuss. So I said that let us brainstorm together and juggle ideas which may go into answering such a question. So once we get that done, then we will arrange them in a logical order. Okay, so I think somebody has put some of the things we are talking about, or somebody has attempted his own points. As mentioned, the Ghana Police, Yoko Special Prosecutor, and then it's also saying that challenges political will to prosecute, non-digitized platform, refusal to adopt ANA's principle, see Brewers Act issues. Okay, all right. So a question like this, I think, require us to be creative about what you know. First of all, regarding no constitutional law, no criminal law, and of course Ghana legal system. All of those things are relevant in trying to generate ideas to respond to such a question. And again, if you have the structure of your answer, of course, the introduction, you definitely acknowledge reality of the problem. Because if you don't acknowledge that corruption, and abuse of office, for example, are actually on the rise, or we encounter them on increasing basis in our country, then there's no point. So you need to acknowledge that. And if you have instances, you can probably cite some examples, that is fine. And then you give a roadmap, what you are going to do in the rest of the answer. So what we call like the signposting, right? You do signposting in the introduction so that we know exactly what you are going to do. So if, for example, we whatever, I mean, all of them, is it the case that we don't have the necessary legal framework, the necessary legal infrastructure to enable us deal with corruption? Or is it the case that the legal structures are there, but they are not resourced, or they are not actually working? So what we have done, most of the things you put down there are just pointing to the fact that we have some legal arrangement, legal frameworks on what need to be done in order to address the problem of corruption or abuse of office. And so you mentioned the Office of the Auditor General. The Auditor General, of course, recently the release of their the release of the Auditor General's report, for example, has generated please, somebody, if you are not contributing to the class, mute yourself. Otherwise, your discussion is coming here. Sorry. Yes, please do that. Just mute yourself so that it doesn't come here. Thank you. Yeah, so the Auditor General's report released recently, for example, has generated interest in some of these issues, and it is not out of place for us to entertain a question like this. After all, your examiners also live in the country, and the type of exams that you are doing, it will not be out of place if we have current issues, so long as they relate to the 6 examinable subjects, as it were. And again, we've also seen the controversy or the exchanges between Office of Special Prosecutor and then the customs officer or something like that. And all those things actually letting us see some kind of interest around the issue. So it is a good thing that we are thinking about it. So first, the Auditor General, what is Auditor General supposed to do? The Auditor General, if you look at the Article 187 of the Constitution, which set up the office of the Auditor General. If you look especially at Article 187, Clause 2, it makes the point, and I quote, that the public accounts of Ghana and of all public offices, including the courts, the central and local government administration of the universities and public institutions of like nature, of any public corporation or other body or organization established by an act of parliament, shall be audited and reported on by the Auditor General, unquote. So, therefore, how public money, public funds is used in any area within the public sector, the Auditor General is supposed to review and ensure that it conforms to the prescribed standards of financial administration. We have like the Financial Administration Act, we have the Procurement Act and all that. All these define processes which must be followed in order to spend money in the public sector, and also in order to acquire or procure goods and services and all that. So the Auditor General's job is to ensure, is to go over how these things are done in the institutions that mentioned. Of course, every institution in the public sector can go there, and then report to Parliament. Report to Parliament so that if there are any infractions or there are abuses that can actually be discussed and necessary actions taken. So please, let us look at just one article, 187. So if you look at 187, Clause 9 and 10, for example, which says that, and I quote, a person aggrieved by a disallowance or a surcharge made by the Auditor General may appeal to the High Court. And then 10, the rules of court committee may by constitutional instrument make rules of court for purpose of Clause 9. Now, if we look at Article 187, part of the powers of the Auditor General is that where it has made a discovery that maybe somebody did not follow laid down procedure, or someone has actually used money which was not supposed to be used and all that, he has the power to search out. To search out the person means that to order the person to restore the money back, the money that the person has taken or has used, which was not supposed to have taken or not supposed to have used it, to restore it back to the state. So that is the power of the surcharge. And where, for example, you have been surcharged and you think that it is not right for you to be surcharged, you can go to court and for the court to actually reverse the surcharge which the Auditor General has made, or the disallowance. So that the disallowance, for example, let's suppose that you have actually incurred or spent certain money or classify certain expenditure and all that. The Auditor General can disagree and say that this money should not have been taken, or you shouldn't have incurred this expenditure. So we are going to disallow it. And if you disallow it, what it means is that the money must be restored back to the state. And if you disagree, you have the right to go to court and challenge. So class are we saying that this particular aspect of the legal framework there is not adequate? Of course, recently, I think Professor Azai, Professor Azai, commenting on the Auditor General's report, also expressed concern that it should have actually do more of like surcharging and taking steps to recover the money than just making it available to the public, only that. Yeah, so is it the case that over the years, those who Auditor Generals, when they do their audits and all that, they don't make use of the powers to recover monies which they think ought not to have been spent or taken from the public purse? So let's keep that in mind. We come back to, somebody has just raised an issue as to whether we cannot discuss corruption. Of course, you cannot define corruption. We need to define corruption, certainly, as part of the introduction. We need to define corruption as part of introduction. And defining corruption, okay, who else can you see the chat? Yeah, can you also define corruption? Yes, you can define corruption. And somebody has also put the Occupy Ghana against the Auditor General there. Okay, just along the lines of the comment that Kwaku Azar or Professor Azar made. Okay, now Attorney General, how does Attorney General comes in talking about corruption and talking about abuse of office? Attorney General becomes relevant with respect to prosecution, especially. Of course, not only prosecution, even the civil. Attorney General, of course, will prosecute the criminal offenses in the name of the Republic and all that. So the Attorney General is important. And the other challenge has to do with the how these cases, criminal cases, sometimes you have so much delay, and the Attorney General, people will petition the Attorney General to take over dockets from the police during the prosecutions and all that. And also how even the police prosecutors may not even appreciate maybe some complexities of certain type of corruption or abuse of office cases. And you need more lawyers at the Attorney General Department to take up the criminal dimensions of corruption and abuse of office, and also even to help the Auditor General, right? Because the Auditor General has the power of surcharge and other people to restore money, right? Other people to restore money that you're not supposed to have taken. So let's suppose that you have been surcharged or there has been disallowance and you haven't brought the money. You have to be dragged to court for for you to do the needful. And all this, we know that you need lawyers to do that. Okay, somebody has brought up another issue as to whether we cannot include Article 286, Code of Conduct, on the declaration of assets. It's very important. 286 is very important. I agree with you. 286 is very important. And even, let me, those who are watching this in Article 286. 286, that is a code of conduct for public office holders. Declaration of assets. Yeah, so we come and talk about, okay, let's even tie that in, that if we take Article 286, which requires that, that if you are, a public, 286, let me quote, a person who holds a public office mentioned in clause 5 of this article shall submit to the Auditor General a written declaration of all property or assets owned by or liabilities owed by him, whether directly or indirectly, within 3 months after coming into force of this constitution or before taking office, as the case may be. B, at the end of every 4 years, and C, at the end of his term, and so on. Good. So if the code of conduct for public offices, in particular, the requirement to declare your assets before you start exercising your office or when you are leaving office, if it's done properly, and if the Auditor General is to also be given the power to look at the declaration made, so that if an audit, for example, is done and a particular office holder is said to have used money in a way which ought not to have been used, and such charge is made, because the person's asset is known, it should be easy for the state to actually get its money, but even probably levying execution against that person's properties, as the case may be, because your properties are known to the state through the declaration of assets and liabilities, which you made upon assumption of office or when you were leaving office, as the case may be. Then other destiny has disappeared. Hey, our points have disappeared. But somebody deleted it. Okay. Oh, sorry, those who are looking at the board, they know that through mistake or whatever, I've made the points we are discussing to disappear. Let me see if it will. Oh no. I think we've lost the. I don't know if probably press something. I'm not sure about it. Disappeared. Remove our points, but the other point which also came up, somebody mentioned National Commission of, for Civic Education. Yes, that is also good to create the general awareness, because dealing with corruption, abuse of office, or trying to build integrity, it's not something which is achieved overnight. So we have to get a lot of education, a lot of ethic training and all that, so that this is properly inculcated. But what about the issue that people will say that, okay, Ghanaians, their salaries and remunerations are not enough, and for that matter, it fits into the culture which sustained corruption and abuse of office. What will be your response to that? And especially this cultural practice of gifting, right? Gifts and tipping, giving gifts and tipping, which is so much, very much part of that. Should it be outlawed in all public sector? So these are some of the issues that, but as I said, in a question like this, certainly it calls for creative thinking, making use of the relevant knowledge background. And the relevant knowledge background are what we have mapped out over here. But the rest is how you systematically bring everything together in a very coherent fashion. And don't forget, the question said discuss, right? So when you are asked to discuss, you need to avoid being merely descriptive and merely expository. If you just provide expository or just a descriptive narrative, you get marks all right, but you are not going to get good marks because you haven't actually engaged in critical thinking. The question said discuss, and when you are asked to discuss, you are supposed to both look at both sides of the matter, and then you do some thinking, some critiquing, as it were. So, for example, if you are arguing that you have Office of Auditor General, Attorney General, NCC, Special Prosecutor, I have even the Code of Conduct requirement for declaration of assets and all that. If you have all those things, and so what? You must ask yourself, if we look at how the law has actually set up these various bodies, which are supposed to play important role in ensuring that corruption is minimized or even eliminated. Do you think that from how the law is framed, how the law is formulated, architecture of the legal infrastructure, do you think it's really something that is fit for purpose? The institutions, do they have enough powers under their relevant law? Or you think that there are certain shortcomings as far as the law itself is concerned, for which reason you may want to see some amendment or some changes to enable them to be able to deliver on their mandate? So these are some of the things that we need to think about. And you certainly need to have a good conclusion. You need to have a good conclusion, and then your conclusion is always just to quickly pull the key argument that you have made together, and then let us know finally what is your take, because there's a claim embedded in the question. For example, if you take the question that despite the manifold laws and institutions, corruption remains endemic in Ghana, the claim embedded in that question is that we have laws and institutions meant to address corruption, and yet we have corruption. So do you agree? Do you agree with that claim? In addition to all, so that is the claim. And at the end of the day, when you put all your arguments together, you need to actually let us know whether you agree with the claim or you don't agree with the claim. In other words, whether the claim is valid or is not valid, whether it is true or is not true, as it were. Or just like the other question, that increasing allegation of corruption and abuse of office by public office holders, that is also a claim which which is contained in the question. So when you've done all the discussion along the lines that you are looking at, you have to let us know whether that claim is true or not true, whether it's valid or not valid, or whether it is over exaggeration, right? Is it an overstatement? Okay, so we'll leave that here. Then we take a last question and then we end for the night. Yes, any? Okay, let me see. There are some questions in the chat. Let's see if we can pick one or two. So somebody said that I have Okay, so we have a question in the chat. Somebody is saying that assuming you are being invited to make recommendations for, please mute yourself. Somebody is please mute yourself. The one who is having a private conversation. Thank you. Please mute yourself. Your private conversation is coming here. Okay, so we have this question from someone. I just picked it from the chat. Oh, so let me see. See if I get it back in. The question said that assuming you are being invited to make recommendation for amendment of the Constitution, which constitutional provisions, in your opinion, must be amended? Okay. Okay, so that is the question. I just copied this from the chat. So somebody said that assuming you are being invited to make recommendation for the amendment of the Constitution. Just ignore the spelling. I know when you are doing the chat, sometimes you can make just unintended errors. So just forget about the mistakes here. Assuming you are being invited to make a recommendation for the amendment of the Constitution, which constitutional provisions, in your opinion, must be amended? Must be amended. Okay, so that is the question the person has posed. I think we have done one mini lecture on constitutional amendments. So please, if you are not part of that lecture, go and play that recording. Go and play that recording in which we discuss the procedure and the processes for amendment of the Constitution, both the entrenched and then the non-entrenched. And then we also look at the work of the Constitutional Review Commission and how it fits into amending the Constitution and all that. And of course, the person who has raised this question, I'm sure the person is also mindful of the recent effort by the majority leader of Parliament and the Minister of Parliamentary Affairs, Honorable Chieh Mensah Bonsu, who has set up, I think, a committee, right, of some Ghanaians, I think, including my own friend, Professor Abuchi, to make, do a study and make some recommendations for amending or reforming the 1992 Constitution. So on that basis, I think that it is legitimate for whoever, Dorothy or whoever put the question there, to imagine such a question. Because if we look at the trend of question, almost every year there is a constitutional law question, or yeah, so it's not out of place. Good. So if you have a question which is inviting you to, for example, identify constitutional provision which you think are candidates. Okay, let's put it this way. Yeah. So identify constitutional provisions which you think need to be amended, and make a case for their amendment, right? And make a best case for their amendment. So that is the question. Identify constitutional provisions which you consider necessary to be amended, making a best case for their amendment. So that is what the question is actually asking us to do. Now, so if you have a question like that, as we say, you need to be logical and structured so that we have a coherent response. And every essay question will have a good introduction. So the introduction in a question like this says about the amendment. First of all, you make the point that Constitution being the supreme law of the land, as we know under Article 1 and Article 2, being the supreme law of the land, it is a law which should not be changed or amended lightly in order to ensure that you have stability and all that. Nevertheless, since society is not static, society is dynamic, you cannot rule out the need for amendment. And that is why the framers of the Constitution have provided Chapter 25 as a framework to govern how the Constitution can be amended in order for the Constitution to reflect the changing needs of society, in accordance with observation the Supreme Court made into 4 versus Attorney General, that the Constitution is a living organism capable of growth and all that, meaning that the framers of the Constitution could not have foreseen everything at the time that they made the Constitution. For that matter, we need to adjust the Constitution to align with our priorities as a society, as a nation. Therefore, we have 2 categories of provisions in terms of amendment process: entrenched provisions and non-entrenched provisions. Entrenched provisions are more cumbersome to amend, as it directly involves the public in the form of referendum and all that, and also require special endorsement at referendum for you to carry through and all that. The non-entrenched provisions are relatively easier, since the amendment is just part of the ordinary legislative process, just as Parliament pass a bill into legislation. For that matter, it is relatively easier to get that through. And then you make the point that there have been a lot of developments since the last nearly the last 30 years in which the Constitution came into force. And those developments have actually necessitated that we rethink and we amend certain provisions of our Constitution. Now you proceed to identify them. What are they? What are the ones you are trying to mark as candidates? So, well, Ulu, for example, consider the provision relating to the Deputy Speaker presiding over proceedings and voting or not voting in absence of the Speaker. Do you think is well, at this stage, I must say that the best way to go about this type of question, if you don't want to struggle your head, is to go and get the report of the Constitution Review Commission, right? Although that was in 2010, some 12 years have also elapsed. So maybe there are certain developments which have taken place since 2010 to now, which were not also considered by the Constitution Review Commission. And probably those ones are not there. But by and large, you still get those things there in the Constitution Review Commission report. So you can take, for example, when it comes to the district chief executive, right? The DC or MC or when it comes to the district chief executive position or the metropolitan chief executive position, should it be an elective position so that it will be elected just like how we elect MPs, right? Or we allow the various political parties just as we elect president, so that if you want the DC for a place, it will not be just like a nomination by the president. Anybody who think can be the DC can put himself up. At the moment, the constitution does not allow it that way. It only says that the president will nominate and then the district assembly will have to vote upon that particular person and so on and so forth. Now, if you look at the report of the Constitutional Review Commission, there are some useful suggestions regarding changing that provision. And of course, we've also seen that an attempt was made by the current government to even get a referendum done so that that provision, which is entrenched, will be amended as it were. So that is one. Another provision which has also come up, aspect of Article 88, right? Aspect of Article 88 of the Constitution. That is on the Attorney General, especially Article 88, clause 3 and 4, which says that Attorney General shall be responsible for the initiation and conduct of all criminal prosecution of prosecution of criminal offenses in the country. Now that has also come up as a candidate for amendment. But some people of the view that let us decouple the prosecution from the Attorney General's office, so that we have like a different or independent body responsible for criminal prosecution. And then the Attorney General will just remain the chief legal advisor of the state and then the government, as it were. But when it comes to criminal offenses, the Attorney General should not have any role. It should be under a separate body with its own leadership. And the argument made is that if you look at the power of the Attorney General regarding the use of nolle prosequi, right, NP, nolle prosequi, where the Attorney General can, for example, say that it has immediately discontinued criminal prosecution, even if it is just at the stage of delivering of judgment. That will be it. So an argument is made that that power will be abused, for example, by highly political minded Attorney General, so that there will be selective prosecution. So in order to address the problem of selective criminal prosecution, let us decouple the criminal prosecution mandate of the Attorney General from the Office of the Attorney General, so that we have an independent body. So if you look at the Constitutional Review Commission report, you will find useful suggestion on this particular issue too. And you can even reinforce that argument by alluding to the creation of the Office of Special Prosecutor. You can create that argument and say that the fact that we have the Office of Special Prosecutor reinforces the need for the prosecutorial function of the Attorney General to be decoupled from the Office of the Attorney General. So that is another one. What else? What other candidates, what other provision you think are candidates for amendment? At least I've discussed with you. There are more, but you should also tell me.
Hello, Doc.
Yes, Abdul Rahman.
No, this is not Abdul Rahman. This is Anand Bentun.
Okay, all right. Okay.
Yes. Yeah, dog. Only the majority leader again proposed that the office of the vice president must be scrubbed off from our constitution. So I think that one also can come up maybe as a possible area
candidate.
for.
Okay. Okay, so office of the vice president. Yes, I think I was he did a lecture at our university. I think about 2 months ago at Kent University, and I sat in that lecture. So he made the argument that yes, the fact that the vice president does not really have any serious prescribed functions and all that, and the functions that the vice president will perform depend very much upon the type of relationship between the vice president and whoever the president is, means that is not really fit for purpose and so on. For that matter, even if you don't have it, it will probably not create any big problem. Of course, as whether you agree with him or you don't agree with him is entirely up to you. All that matters is that you are able to marshal logical arguments. Your arguments to be consistent with some logical coherence. Once you've done that, no one can fault you. Okay, so I think that so when you are done, we cannot exhaust all those discussion here. When you are done, then you have to also draw a conclusion, as it were, that these are things that as to whether some provisions are really in need of reform is very much dependent upon the thinking of the Ghanaian voting public. And for that matter, if the provisions we are thinking about are entrenched provisions, for example, and then they go to the crucible referendum, if they get the requisite approval, then it means that your argument that they need reform will have been vindicated. But if they don't get approval, then that is it. Because this one, when it comes to constitutional matters, this is not mathematics, it's not the rocket science. It depends upon what the people want. So what the people want at the end of the day, and it's part of the right to self-determination. What the people want is what will carry the day, and not whatever arguments that you want to marshal, as it were. Okay, so we leave that here, and it's getting late. So I would like to draw the curtain down tonight. We'll continue tomorrow evening. So have a good night.